Look, Mr. Gregory, and I'm not expecting for you to respond. I'm going to set this case for a pre-trial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
Buckle up, geese, today. We're diving headfirst into courtroom chaos. And we're starting with a defendant who's testing the judge's patience for the very last time. This guy is out on bond for driving without a license. And what does he do? He keeps driving. The judge is done playing nice. And this moment sets the tone for everything that follows.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say?
Watch as courtroom tolerance finally hits a brick wall, and a bond gets handed out with some serious side-eye.
Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir, no.
Get out of here.
Guys, here's where things really escalate. A new defendant walks in right in front of a group of kids on a courthouse field trip. Pand manages to drop an F-bomb on the judge. That's not just dumb, that's self-destruct mode. The judge wastes no time snapping back with authority, tossing her straight into custody. What starts as a routine arraignment ends in total
700-388, the state of Michigan versus Bradley Peterson. Okay, counsel, you're Mr. Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, your name for the record, please.
Brady Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably, and at this time I would ask to be allowed to recuse myself from this case.
Get ready for this one. We head to a different courtroom, and things take a left turn fast. A defendant and his lawyer hit a total wall over a motion. The client filed without consent. The lawyer straight up asks,
Are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case, is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court
to leave the case, citing irreconcilable differences in legal strategy. It's calm, civil, and yet full of tension. This is what happens when courtroom delusion starts bleeding into real consequences for everyone involved.
Okay, we don't have videotape. You can request a transcript, certainly. Yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it, and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault at City of Haven. We did it over Zoom. But
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just a transcript.
recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts.
Okay.
You can just request a transcript.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Entering sovereign citizen territory. The defendant thinks he knows the law better than the court, and it shows. He starts demanding video evidence from a Zoom hearing that was never recorded.
2.003, I believe I filed that on the 17th on Friday or something like that. So
Okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course. I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
Yes.
That's all of this one. And we filed something on January 17th, and you're requesting under 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. The fair bond condition and restrictions to stop U.S. public protests at city and Glen public schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate.
Refusing to understand court procedure. The judge tries to reason with him, but this guy is already deep in his own fantasy version of the law. This isn't a defense, it's a derailment, and it's painfully clear who's in control. This is the moment it all unravels. The defendant brings up a federal case he claims proves the court is violating his right, sect. Spoiler alert, it proves the opposite. He cites a judge who ruled against him, misrepresents the case entirely, and actually strengthens the court's position. This is peak sovereign citizen logic where the facts don't matter as long as they support the narrative. It's delusion. Dressed up in leaking. If you thought we hit rock bottom, think again. The defendant now claims he wrote his own constitution and says the court is violating his European rights. Yes, you heard that right. The judge holds steady, laying out exactly why bond restrictions are legal and necessary. But the guy just keeps pushing nonsense. Watching him try to twist basic legal principles into a personal persecution fantasy is both baffling and bizarrely entertaining.
That's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir,
I'm with you.
the allegation is that you assault or resisted, obstructed a police officer causing injury and trespassed.
That's just an allegation.
You're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
No, you need to read the whole thing, other than just one. I got like 15 issues in there.
15 issues.
Yeah,
Okay,
you need to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
Okay.
But none of your police came out to arrest me because that's my constitutional right to do.
You're
I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over.
Off the rails here. The defendant says he should have been arrested. For protesting? Yes. He's mad the police didn't arrest him. The judge calmly reminds him that she has no power to arrest anyone. But he's already deep into his performance as a misunderstood martyr. This moment captures sovereign citizen mentality in its rawest form, confusing justice.
If I followed your white laws, I follow them, and then you stomp on me when I followed your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys took dogs out.
Stop right now. I'm not 100 years old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay, yeah, don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven, though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
Yeah.
took an oath to uphold every citizen's constitutional right to public protest. But
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did?
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which this court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse, and it was okay. You should have arrested me then. When I go to your schools,
I don't
I'm
have
wind
arrest
out.
warrants.
When I go to schools.
Here's the grand finale. The defendant pushes one. Last time for the judge to recuse herself, accusing the court of bias, ignoring history, and even bringing up Martin Luther King. The judge keeps her cool, emphasizing,
I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, and this. I'm trying to tell you I exercised my constitutional rights, and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been
I don't-
through your system before.
So
Also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment,
Hear it.
just one moment, please. This court, sir, has to take the allegations and there's a process.
Like I don't know it. I know your process. I've been down your roads before. But
I don't know
I'm
what roads
15.
of mine you've been down, sir.
I'm 15,
But you've
the
been here,
defendant-
excuse me, you've been here in this court a number of times,
Yes,
as
I have.
other matters have been disqualified.
Yes, I
And you
have.
have been treated with respect and fairness. And I believe you've even
That's
stated that
not
yourself.
all entirely true.
Hold on, sir, I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs.
What?
You didn't show up then.
Hold on, sir, I don't even know what one that is you're talking about.
Well, it was the one that we was going through and postpone. The City of Woodhaven
the
wrote
federal one?
violation. No, they wrote violations, I mean, for posted signs in this case, in other cases. Because I was protesting in the City of Woodhaven.
Okay.
But on that, the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid, I'm not. But I'm 15.
Stop there right now, sir. Stop there right now. I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year.
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had